Greetings, brethren and sisters. Taking a look out of Black's Law Dictionary. This is the 4th edition. It's about half a water bottle wide. Let's take a quick glance into what prima facie means. Prima facie. In Latin, it means at first sight, on the first appearance, on the face of it, so far as can be judged from the first disclosure, presumably, a fact presumed to be true unless disproved by some evidence to the contrary. State Herbert versus Wims, Ohio. Prima facie. Prima facie case, such as will suffice until contradicted and overcome by other evidence. Pacific Telephone versus Wallace, Oregon. A case which has proceeded upon sufficient proof to that stage where it will support finding if evidence to the contrary is disregarded. Hoagland's State, Nebraska. A litigating party is said to have a prima facie case when the evidence in his favor is sufficiently strong for his opponent to be called on to answer it. A prima facie case, then, is one which is established by sufficient evidence and can be overthrown only by rebutting evidence adduced on the other side. In some cases, the other question to be considered is whether there is a prima facie case or no. Thus, a grand jury are bound to find a true bill of indictment if the evidence before them creates a prima facie case against the accused. And for this purpose, therefore, it is not necessary for them to hear the evidence for the defense. Mosley versus Whitley, State versus Hard L. Lynn, M.O. So, sufficient evidence that can only be overthrown by rebutting evidence. Prima facie evidence. Evidence good and sufficient on its face. Such evidence as in the judgment of the law is sufficient to establish a given fact or the group or chain of facts constituting the party's claim or defense, and which, if not rebutted or contradicted, will remain sufficient. State versus Burlingame, Mo. Evidence which suffices for the proof of a particular fact until contradicted or overthrown by other evidence. Dodson versus Watson, Texas. Evidence which, standing alone and unexplained, would maintain the proposition and warrant the conclusion to support which it is introduced. Evidence which, standing alone and unexplained, would maintain the proposition and warrant the conclusion to support which it is introduced. Gilmore versus Modern Brotherhood of America, M.O. An inference or presumption of law, affirmative or negative of a fact, in the absence of proof, or until proof can be obtained or produced to overcome the interference. Inference. People versus Tharcher, New York. A litigating party is said to have a prima facie case when the evidence is in his favor is sufficiently strong for his opponent to be called on to answer it. A prima facie case, then, is one which is established by sufficient evidence and can be overthrown only by rebutting evidence adduced on the other side. Mosley versus Whitney, State versus Lawler. A prima facie case is one which is apparently established by evidence adduced by plaintiff in support of his case, up to the time such evidence stands. Up to the time evidence stands, unexplained and uncontradicted. Morrison versus Flowers, Illinois. A prima facie case is one in which the evidence in favor of a proposition is sufficient to support a finding in its favor if all the evidence to the contrary is disregarded. Schallert versus Boggs, Texas. Presumptive evidence. the Private Law Dictionary, 2nd edition. It's out of Quebec. It is about a quarter of a water bottle. Prima facie, at first sight, on the face of it. And in French, it's prima facie. And then over here. Right. It does not have evidence in it. It goes right from eviction all the way to EX for some reason. And then case. Judd law. Matter submitted to a court, usually of a conscientious nature. The superior court is authorized to consider every case which is not within the exclusive jurisdiction of another court. Canada National Railway Co. versus Trudeau. And in French, evidence is pre-juve, and goes right from T and skips to RI. So yeah, no French.